Welcome to Sparks of History, where Jewish history and world history meet. We are extremely pleased and honored to have with us today Professor Michael Helfand. Professor Helfand received his BA from Yeshiva University, as well as JD law degree and PhD from Yale University. Professor Helfand is currently the Mann Foundation Chair in Law and Religion and co-director of the Nootbaar Institute for Law, Religion, and Ethics at Pepperdine Caruso School of Law. Additionally, Professor Helfand serves as the senior legal advisor to the Orthodox Union's Teach Coalition and is a senior fellow at the Shalom Hartman Institute. An expert on questions of church and state, Professor Helfand's work considers how U.S. law treats religious law, custom and practice, and his academic articles have appeared in numerous law journals, and his writings have been featured in various publications, including the Wall Street Journal and the LA Times. Professor Helfand, thank you for being with us. We appreciate it very much.
Pleasure being here today.
Okay. The great bulwark of American society, the separation of church and state. What did the founding fathers, have in mind by the principle of separation of church and state? Is that separation of church and state still alive and kicking today? And has the concept changed over time? Is that enough? Is that enough to begin with?
No, give me more. Give me more. Let me try to say a little bit about this, but it's everything I'll say will be inadequate on this front. You know, one of the most interesting features of separation of church and state, first of all, it doesn't appear in the Constitution or its amendments. It's a term first used by Thomas Jefferson. The First Amendment simply says Congress shall make no law respecting an establishment of religion. And kind of the instinct over there was that Congress or the federal government shouldn't, let's say, take control over religious matters. You know, when you say it that way, you begin to realize that way back when, the idea probably was, historians still continue to debate this, probably was that the federal government should have to stay out of matters of religion, but the states, they actually could continue to, in some ways, have establishments of religion. And that's how kind of the idea there was like a federalism fight, like who's going to have control over religion, but it wasn't that government was going to stay out of religion. It wasn't, at least not everyone thought that meant that you were going to actually have church and state separated. It was only in the 19th century with the 14th Amendment and then the 20th century when the 14th Amendment was interpreted, oh, this is going to be a lot of jargon, when it was incorporated against the states, meaning when the Supreme Court decided that the First Amendment wasn't just going to apply to the federal government, but also to states, then you started having this concept, this principle of separation of church and state, that government cannot establish religion. Then it started to be applied actually to the states. And that's probably where you get this kind of the modern conception of separation of church and state. I think it kind of is surprising to folks, but that actually happened in 1947. So up until then, it wasn't clear that states couldn't have some sort of establishment of religion. Now, you know, kind of legal theory and actual practice are very, very different things, and states themselves disestablished. They kind of started separating church and state on their own. But like as a legal concept, the concept of separation of church and state, as applied to like all facets of government, in many ways is kind of new. And kind of the heyday of separation of church and state is really kind of 1947, maybe until recently. Oh, you asked me that as part of the question as well. It was a compound question. I should have objected. So that's kind of where you first get this concept of separation, or really the modern incarnation of separation of church and state. Now, like, what did that include? You know, historians debate this a ton. It's very, very challenging to figure it out. It certainly seems like it included things like the citizens' taxes shouldn't be commandeered in order to support a religion. It probably also meant that government could not prefer one religion over another. It probably also meant that no citizen should be coerced into practicing a particular faith. Beyond that, you end up with quite a bit of fights over what separation of church and state means. And maybe I'll wait till a follow-up question to say a
Okay.
little bit more about that.
Okay. Well, what does separation of church and state mean to you, and why is it important to you?
So that's a great question. In many ways, the separation of church and state, the idea, the concept, it's very Jewish. What I mean by that is, Jews in many ways and Jewish organizations and institutions in the United States were some of the big proponents. And in many ways, they were the advocates who mattered in terms of fashioning the modern conception of separation of church and state. You can probably see why. The idea in a predominantly Christian country, the idea that church and state have to be separate in some way, whatever that might entail, created space for religious minorities to operate, to function, to thrive. And so it's not by chance that organizations like the American Jewish Committee, the American Jewish Congress, the Anti-Defamation League really pushed hard in the 40s and the 50s and the 60s to build out this idea, this concept of separation of church and state. In many ways, they viewed it as holding the key to unlocking the promise of the American dream, that just because you're of a minority faith doesn't mean that you can't have full access and full rights to participate in the public square. So it's a very Jewish concept, and I think that's what makes it attractive to me as an idea. The puzzles, kind of as your first question alludes to, is really about line drawing, and this is where a lot of issues have come up more recently. I think American Jewish organizations are deeply committed to the idea that nobody should be coerced to practice a faith that isn't theirs. But, when you start getting to questions about, I don't know, public displays of religion on government property, here some American Jews, especially Orthodox American Jews, start, you're not sure what you get when you ask somebody. The Lubavitcher Rebbe famously supported the concept of having a moment of silence or prayer at the beginning of the public school day, although he didn't want it to be like have particular sectarian, particular religious content to it. But the idea that religion will play a role in public life is in some ways attractive to Jews. When it becomes coercive, it becomes far less attractive. And then trying to figure out where the line is between kind of, mere symbolism and coercion. Well, this is what law professors spend a lot of their days trying to figure out.
Okay. If we're talking about symbols already, the Ten Commandments, for some people, the Ten Commandments is Cecil DeMille, Yul Brynner, and Charleston Heston. For others, it's deep commandments and multiple commandments coming out of the Ten Commandments. What was the issue surrounding the placement of the Ten Commandments?
Yeah, Ten Commandments is such a great example of this phenomenon, like the line drawing problem. 1980, the Supreme Court issues an opinion, a kind of short opinion in a case called Sohn v. Graham, where it says, no, you can't have the Ten Commandments on display in public school classrooms. That's certainly a separation of church and state problem. But as this current Supreme Court has increasingly kind of limited, what this concept means and how it applies, really a far more historically grounded version of what separation of church and state means, people have begun to wonder. And Louisiana is kind of testing the limits by announcing by January 1, 2025, every public school classroom is going to have the Ten Commandments on display. So, you start thinking about it like, is that a separation of church and state problem? If all you care about in life is you think the problem is, I don't want to be coerced or forced to engage in any sort of religious activity, you might say to yourself, there are 10 commandments on the wall. It's not forcing me to do anything. There are lots of pictures on the wall. It doesn't bug me. In the 70s and the 80s in particular, and until recently, the Supreme Court thought that separation of church and state required more than just protection from coercion. They were explicit about this, in fact, in the 60s. They thought also, depending on which justice you ask and which opinion you got, they thought it also prohibited certain forms of endorsement of religion. Government saying, we like this religion, and the people who followed this one, they're the good people, and the people who don't follow it, they're the second-class citizens. They're not really, on board with the program. And if you take that view, you can see how having the Ten Commandments might be a problem. The Supreme Court has now, in recent years, said, no, we don't care about this concept of endorsing or endorsing one religion over another. That doesn't bug us as much. And so people wonder if it's really just about coercion. Maybe you can have the Ten Commandments on the walls of public school classrooms. I've been puzzling about this myself quite a bit. I'm still uncertain about what I think about that. I have this instinct that maybe there's still a problem with having the Ten Commandments on the walls of public school classrooms. Maybe it's a problem when you're dealing with circumstances where the government seems to be preferring one religion over the other. I mentioned that at the outset. There's some evidence from the founding period in the United States that the founders worried about this idea of denominational preference, that they're going to use their voice to say, we kind of like this religion, and maybe ever so gently to nudge people in that direction. Not quite coercion, but you can imagine people using symbols and power and authority to nudge people ever so gently in favor of a government-preferred religion. And maybe we should still worry about those ideas when you have the Ten Commandments on the walls of public school classrooms with impressionable children. Maybe there's still something problematic about it. I guess in some ways we may have to see how the actual program in Louisiana plays out.
So would this be different because it's in a public school than a Christmas tree on a government building, a menorah, Hanukkah on a government building,
Right?
a Buddha statue on a Muslim symbol? Is that different because it's a school, or is that just a nuance that really is not that relevant?
If you're asking like present day, if we kind of called up the nine justices on the phone and said, hey, yo, like, what do you think about this?
Can you do that? Can you do that?
I can't. Maybe you can. I don't know.
Okay.
No, people wonder. I don't think we know the answer to that question. I'll say, like, on the view I just expressed, you'll notice like I weaved in the fact that you've got impressionable children in a classroom, and children have to go to school, right? Compulsory education law. And so you might start thinking about those circumstances differently than kind of a passive display, like when the Ten Commandments are displayed, at the Texas Capitol. That's a case from some years back. You might think about that differently, like it doesn't have, if you buy my nudge argument, you might think that doesn't nudge me as much. I'm just passing by, hanging out at the Capitol. I can come, I can go. That doesn't have the same torque, the same force. Now, the Supreme Court may not go for that. The Supreme Court may say we just care about coercing people to engage in religious practices that aren't theirs. And if you think that's all it is, a display is a display. It's not, it doesn't jump off the wall and make you do something. So I don't think we know. And I suspect these rules that we're seeing Louisiana enacting legislation to put the Ten Commandments on public school classroom walls. Oklahoma has announced that every teacher is going to have a Bible in the classroom, which they're going to be required to teach from. Now, what are they going to be required to teach? How are they going to be required to teach from it? There are, let's call it, more and less robust ways to do that.
So by Bible now we mean Old Testament and New Testament, or
I don't believe the memo said. I think it just said Bible.
Okay.
So that in and of itself,
like they used to put in the motel rooms, the Gideon Bible in the motel.
By the way, there was a theory way back when, I think it was Justice Brenden, who suggested that the very idea, like deciding what you pick and how you pick, the very version of the Ten Commandments that you pick, Christians have different versions, and Christians have different versions than Jews. You might say to yourself, like, that in of itself is you're picking one faith over another. Maybe that in and of itself is a problem. It's never gotten much traction, that view. But we'll see. And kind of, I think you've captured that in the ambiguity of, like, when legislation includes the word Bible, well, what do you mean? And whose view of that are you preferring when you interpret it that way?
Has there ever been a legal issue surrounding American currency and the phrase "In God We Trust"?
Yeah, but they've never gone anywhere. There's standing problems. There are a whole host of issues with those. They haven't gone anywhere. But sure, creative litigants have tried just about everything. Yeah, in God we trust. I wouldn't recommend it as a hobby.
Okay. I mean, you're not talking about, you're talking about litigation, not the
That's
fact that
right.
in God we trust.
Correct.
Okay. Moving along to funding of non-public schools. Should the government be involved in funding of religious schools? And if they are funding, do they have a say in curriculum?
Great question. One of my favorite topics, the issue of government funding. This is something I've had the pleasure of working with the Orthodox Unions Teach Coalition quite a bit. It's something I'm pretty passionate about. The concept or the idea of government funding of private schools. You know, this has been an issue that's divided the American Jewish community, I don't know, since at least the mid-20th century. More progressive denominations, I would say, like the Reform movement, conservative movement, have generally been against the idea of government funding of private religious schools, and as a result, private schools generally. And the reason is they viewed it as a violation of separation of church and state. You know, why is government getting involved in what religious schools are doing? That's a real problem. You know, Orthodox Jewish organizations have, at least since the late 50s, early 60s, taken a very different approach. And the approach isn't that you should fund religion. The approach is that if you're going to be funding private schools, then you should also be funding private religious schools. And instead of viewing it as a separation of church and state problem that, you know, everyone's getting money, including religious schools, the American Orthodox Jewish community has viewed it as, wait a minute, you're discriminating against me. I would get this
I'm
money.
sorry, private schools, non-public schools, there's no issue regarding funding?
Well, I'll tell you the story about the 60s, and then
Okay.
and then I'll tell you what's happening now. So in the 60s, when the federal government started thinking about under Johnson started thinking about funding for private schools, American Orthodox Jews advocated for religious schools to be included, private religious schools, and to do otherwise, they said. Moshe Scherer from the Aguda famously testified before Congress making this point. To do otherwise is a form of discrimination. That argument for a long time did not win the day. 60s, 70s, 80s, 90s, even into the 2000s. Separation of church and state was understood. Money from government can't go to religious schools. So you could have some sort of funding program for private entities, but religious schools would have to be carved out. You actually have thousands upon thousands of laws still in the United States that say historic preservation grants for everybody unless you're religious. Funding for, I don't know, a lot of special needs programs have it in there. Special needs schools unless you're a religious school. In the 2000s, the Supreme Court started working its way closer to this, to kind of the view of American Orthodox Jews, Orthodox Jewish organizations. And they did that by focusing more and more, saying separation of church and state. It doesn't mean that, you know, everything's got to be completely separate. It just means you can't prefer religion. You can't give religion more money because it's religion, but you also shouldn't give it less. That's religious discrimination. That's also prohibited by the First Amendment. So increasingly, it was a view that if you treat religion neutrally, that's okay. And then this puzzle came up. Okay, so you have to treat religion neutrally. or at least you can treat religion neutrally. That's fine. That's not a separation problem. What if a state doesn't want to? They say, oh, I'm not sure so much about your listeners, but hopefully this will work. They want to be machmir when it comes to the Establishment Clause. The state wants to say, we get it, we can be neutral, but we don't want to be. We really think it's a problem giving money.
We want a strict interpretation.
Strict interpretation, or to expand the boundaries of separation of church and state beyond what the First Amendment requires. The Supreme Court thought about this a little bit. 2004 heard a case, and they said, you know what, you can be stricter than what the First Amendment requires. And people thought that was the end of the issue. States, if they want to, they can give money to religion, but they don't have to. And, more recently, starting in 2017, the Supreme Court has kind of changed course again. And on this, they've said on three separate occasions that the idea that government would give money to private entities, private institutions, but not to religion is a prohibited form of religious discrimination. And that's been a big deal because, there are lots of programs out there that, private institutions, private schools receive money. And it used to be that you could exclude religious schools, and now you can't. Now, if you're going to fund private schools, you have to fund private religious schools as well. And this has really been a big, big deal. I'd even add that, the legacy of kind of the old rules is there are still states that have thousands of laws on the books in the aggregate, still saying things like no money for religion or no money for religious schools. And I would say as part of the Teach Coalition, I spend a lot of time now thinking about how you either convince legislatures that those are problems now, or you sue states in order to get those rules off the books.
So is when we talk about funding for religious schools or private schools, is that the same as providing school vouchers, private school vouchers to parents? Is that the same? It's the same area that we're talking about?
Can I say, right church, but there are different pews? Does that work under the circumstances?
That's fine.
There are tons of different kinds of funding programs. Okay. Everything from school lunches to busing to textbooks to vouchers. I mean, there are lots of different kinds of fundings. It comes in all shapes and sizes. Right now, I've got litigation going out here in California. California has a rule. There's this federal program called the IDEA. I hope I get this acronym right. Individuals with Disabilities Education Act. And the federal government, what it does under the IDEA is it gives money to states to provide programming services for special needs children. Okay, great. So they provide the funding, but there's a condition. They say to the states, you have to make sure that every single child in your jurisdiction gets an appropriate education, what they call a FAPE. I'm going to stop with the acronyms as quickly as possible. So every kid has to receive an appropriate education. Now, it turns out public schools can't always provide an appropriate education. There are lots of different kinds of children with lots of different kinds of special needs. Public schools are all already kind of strapped in terms of their resources, and it's a hard thing to pull off. So what does a public school do if they can't provide the appropriate education for a special needs child? So the answer is they contract with the private school. So they say, we can't do it. We're going to send tuition and money for ancillary services. We're going to send that over to you, state-certified private school, and you're going to satisfy our obligations to the federal government. Pretty straightforward. California has a rule, and here's how the rule works. You can become a state-certified special needs school unless you're a religious school. So this isn't a voucher program. This is just another way in which you might say, religion, it's one of these kind of everybody but religion. And kind of in my neck of the woods, what that's meant is it's been very difficult. So far, it hasn't really happened that the Orthodox Jewish community here in Los Angeles has had a Jewish special needs school. It's been very difficult to get that off the ground because, as opposed to other special needs schools, you're not, for some of the kids that you would like to bring into the school, you're not receiving the kind of tuition dollars and money for ancillary services that every other special needs school is receiving. And you'll notice that's not a voucher program, right? That's kind of a funky federal state making sure every kid gets what they need. But religious schools, at least in California, are still left on the sidelines.
Got it. And the whole idea of funding and having a say in curriculum, are there states that have come back and said, oh yeah, we'll fund, but you got to teach this or you can't teach that? Has that arisen?
Um, there are kind of two buckets that get close to what you're describing. So on the one hand, you do have states like Maine. They were the ones who were involved in this litigation that went all the way up to the Supreme Court, where the Supreme Court really solidified this rule: you can't exclude religion. So what Maine has done is they've enacted a law that says, or amended their anti-discrimination law to say, if you receive our funding, you cannot discriminate on the basis of sexual orientation or gender identity in your operations. And in terms of hiring, in terms of students. So you can see how these religious schools, in this case Christian schools, that for the first time were able to participate in a tuition assistance program in Maine, are now like, well, now we have an issue. And Maine has also said, by the way, if you don't take our funding, you don't have to abide by it. It's a deal. And this is the matter of significant litigation right now. It's now before, I think, the First Circuit, Federal Court of Appeals. We'll see how it all plays out. If that kind of condition on government funding remains constitutional. So that's kind of one bucket. That's not curriculum, though, so it's not exactly what you were asking.
Okay.
There's another case going on.
It would be like a religious school saying, we only take in males, or we only take in females, and the state coming back and saying, okay, that's nice, but if you want our funding, you got to open it up to males, females, and anything else that's in between.
Yeah, I would just say single sex schools. I'm not aware of any. There are no laws prohibiting a single sex school. Although they might prohibit discriminating in hiring with respect to, again, sexual orientation, gender identity. So okay, so that's one bucket, and that's not curriculum. There's another kind of litigation that's been going on for years in New York. With respect to New York promulgating a variety of rules and penalties under their compulsory education law, which requires schools, private schools, including private religious schools, to teach a whole bunch of stuff, not just kind of English, math, science, history, but a variety of other things, obligations, curricular obligations. For all private schools, but that's actually not linked to funding. That's just part of the compulsory education law. Like, all states have some version of compulsory education law. You can't just not educate your kids. But once you say that you have to educate your child, so the natural next question is, educate them in what? And so you're going to have a list of stuff, or at least a list of objectives of the education that you're providing, like some standard it has to live up to. And once you have standards and rules and requirements, so it's very possible that you're going to have litigation. Back in the 1970s, there was a famous case about the Amish, Wisconsin v. Yoder, before the Supreme Court, where the Amish, they didn't want to send their kids to high school. They wanted to educate them on their own on their farm. They wanted to provide them a certain kind of very Amish education. And ultimately, the Supreme Court greenlit that. They said, even though there's a compulsory education law, what you're doing is sufficient, and given the kind of the parental rights and the religious liberty considerations, you have the right to do that. The New York litigation has been ongoing. It's been particularly pressed by both the Agudath Israel and a variety of let's call them Hasidic schools in New York, primarily. Also, some other schools have really gotten involved in the litigation, and it's currently. If I recall correctly, the plaintiffs have sought appeal to the New York Court of Appeals, which is the highest court in New York. New York, for some reason, the Supreme Court in New York is the lowest court, because why not? We'll see kind of how that plays out. There are a lot of kind of strange and interesting issues there, but one thing to note is it has nothing to do with funding. Even if all these schools didn't take $1 from the government, they still have to satisfy some set of obligations under the compulsory education law. So there, again, it's not linked, and it's curriculum, but not linked to funding. And the Main case is linked to funding, but it's not curriculum. So I guess that's my best go at answering the question.
Those are the buckets. Got it. We're obviously, in a difficult period and witnessing alarming rise in anti-Semitism in America, and obviously the events that have been occurring at college campuses. What kinds of lawsuits and investigation related to anti-Semitism at college campuses are currently being pursued?
Yeah, so this is, I assume many of your listeners have seen kind of, it feels like every day you get another email or another alert, this president has resigned and this school is being sued, and you need a scorecard to kind of keep track of who is where. I actually keep a scorecard. It's super helpful. And the Department of Education, since October 7th, has opened investigations against over 100 federally funded schools for forms of, I should say, for forms of discrimination on the basis of shared ancestry. I'll get to that in a sec. And you've also had over, I think at this point, around, let's call it 20 federal lawsuits filed against universities for anti-Semitism. And these are ongoing. Many of us, I'm following right now the UCLA case, which has really been in the news since a judge's decision last week to really impose a set of ground rules, at least pending the outcome of the litigation on UCLA, to either make all campus programs accessible to Jews, or if there's a program that isn't accessible, physically accessible because of an encampment, because of barricades put up by protesters, the university has to shut it down. So there's quite a lot going on. Maybe I'll try to explain the two kind of in broad strokes, the two big buckets here. This is going to be a long answer. You should stop me at some point in the middle. Okay, so, option A, this is Title VI. So you have the 1964 Civil Rights Act. Some people may be familiar with that. Lots of things in there. It prohibits private institutions from engaging in discrimination. The Constitution talks about what government can and can't do, but it doesn't talk about private institutions. The 1964 Civil Rights Act was intended to address private forms of discrimination. Title VII of the 1964 Civil Rights Act, that's about discrimination in employment. Title IX, gender discrimination in education. Title II, businesses discriminating. These are all private entities. In comes Title VI, and Title VI prohibits discrimination against race on the basis of race, color, and national origin if you are a government-funded private institution. Okay, so you're a private institution, you receive government funding, you cannot discriminate on the basis of race, color, or national origin. So you may say to me, Avi, or Michael, depending on where you bump into me, you may say to me, what on earth does that have to do with campus anti-Semitism? On the one hand, we're not race, color, or national origin, you might say to me. And on the other hand, is it really the schools discriminating, or is it, a bunch of employees and students discriminating? The school hasn't done anything. So that seems weird that you would mention Title VI. And the answer there has been, these lawsuits are predicated on two things. One, for the past, I'd say, 20 years, the Department of Education, really since 2004, has interpreted the category of race, color, and national origin to include discrimination on the basis of shared ancestry and ethnic characteristics.
I assume, Professor, that discrimination on the basis of religion was purposely left out.
It's a great question. So it was in, and then it got taken out, and people think they know why, but they're not sure they know why. It probably has something to do with certain religious institutions that received federal funding but wanted to discriminate on the basis of religion. Now, the reason that's a weird answer is because we solved that problem in other areas of the 1964 Civil Rights Act in other ways. So why didn't they use the patch that they had from Title VII for Title VI? I don't know. There's some, it's not there. And they definitely thought about it, and they definitely didn't put it in. But kind of advocates have, really for 20 years, kind of rejiggered the obligations, the requirements, the scope of Title VI by interpreting kind of race and national origin into kind of refashioning it into this category of shared ancestry, which, when you think about shared ancestry, it kind of sounds national origin-y. And ethnic characteristics you might think is related to race in some way. And the Supreme Court has made this kind of argument in slightly other contexts. So it was adopted from some Supreme Court opinion in the 1980s. The Department of Education has run with it across 4 administrations. So this isn't, something that's obviously left or right. It's really something that kind of both sides of the political aisle have adopted and embraced at different points in time. And so kind of that's point one is like, oh, wait, anti-Semitism is a form of discrimination on the basis of shared ancestry and ethnic characteristics. And point two is the Supreme Court has said, at least with respect to Title IX, and now it's been applied to Title VI, it's not just that the institution is prohibited from discriminating, but it also can't be, quote, deliberately indifferent to, quote, severe and pervasive discrimination. So if there's so much stuff going on, let's say, on a college campus where I can't access the benefits of education, which the government is funding, the government says, no, you've got to fix that. You can't be deliberately indifferent. You have to at least try. And if you don't, you're going to be on the hook. And what does on the hook mean? Could mean a couple of things. It might mean the most extreme version is we're going to pull your government funding, although that's very, very difficult to do. But it probably means we're going to require you to do a better job policing campus anti-Semitism. If you file suit in court, you may even get some monetary damages. That's kind of bucket one. Bucket two, that's become very interesting, at least to me, is this UCLA lawsuit. And the UCLA lawsuit is the first time I think we've seen this. And the claim here is that UCLA, because it's a public institution, it's obligated to abide by the requirements of the Constitution, including the First Amendment. And so what the plaintiffs here allege, 3 students, 2 law students, 1 undergraduate student, is that they couldn't get access to public spaces on UCLA's campus, which is, again, just public space. It's like the sidewalk. Unless they disavowed Israel. And supporting Israel, they allege in their complaint, is a sincerely held religious commitment of theirs. The complaint even makes reference to prohibitions against defaming Israel recounted in the Gemara, in the Talmud, often, at least at times in some more recent legal treatises, Jewish law treatises, by religious Zionist rabbis like Rav Melamed. So, you can see how you might make an argument saying government can't allow for a set of circumstances, can't facilitate a set of circumstances where my access to public spaces is conditioned on my disavowing one of my religious commitments. That's not just like a Title VI, you were deliberately indifferent. If you, government, facilitate this, and that's the allegation, you helped put up barricades, you tried to keep me out of the encampment because, I don't know, you didn't want us to get into it. But what you were doing was you were saying to me, either violate your religious commitments or some parts of campus are going to be off limits to you. And the federal judge last week pressed the argument hard, really had some very, very strong words, at least at a preliminary stage for UCLA, and said that this is astonishing that people's religious commitments are keeping them out of certain parts of, public institutions. That's a non-starter in the United States. And he repeated it. He said, I can't believe I have to say this, but let me say it again. And then he said, that's no good. While this litigation is pending, either make campus open to everyone, or if there's a space that isn't open to everyone, close it down. So these are kind of the 2 buckets you have right now. You can probably subdivide it further. You have people filing complaints with the Department of Education and their investigations. You have federal lawsuits about Title VI, and now you have this kind of new flank that's being opened. Really on the, we're on the precipice of a new school year. And so I think in the coming weeks we'll really see how these legal challenges, to what extent they're able to shape campus culture and campus life.
And what does this all indicate about the place of Jewish issues, anti-Semitism in the public arena, in education? Where do you see this going?
Oh, I wish I knew. I mean, that's just I think for many of us, I have the pleasure of teaching at Pepperdine University. We're a Christian campus. Um, I was in Israel on October 7th, and I'll tell you, I must have gotten emails and texts from, I don't know, just an extraordinary number of people in my university. Like the president of my university was texting me looking for me. My dean's looking for me. So, there are still places in the American Academy that are extraordinarily supportive. And I kind of thank my lucky stars that I ended up at a place like that where I couldn't feel more part and more integral to the academic community. There's that piece of it. But at the same time, we've seen lots of segments, parts of higher education in the United States where there appear to be some real challenges. And, it'd be one thing if, this was just an admixture of really complicated free speech issues combined with religious commitments and, universities were trying to balance. And this can be hard stuff. I get that piece of it. I think the puzzle for a lot of folks, I would include myself, is that for a number of years, the promise of higher education was that it would ultimately try to protect individuals from subjective harm. That flowed from other people's speech. The idea that somebody would say something and even if that speaker didn't intend it, and somebody who heard what the speaker said felt like they were threatened or hurt by what the speaker said, that was considered a problem. And universities tried to implement rules to protect listeners from that sort of harm. And come the campus anti-Semitism debates, and this argument seems to have disappeared. The subjective feeling of harm felt by Jews doesn't seem to carry the same weight as the subjective feeling of harm felt by others. And I think that's really the crux of the problem. I think if universities had been kind of free speech all the way down, and it was our turn, so to speak, and like, we don't like what we're hearing, but this is just how university has been operating forever, and welcome to kind of the marketplace of ideas or the marketplace of protests, and this is part of what it means to be within a community of higher education. I think we could. I shouldn't say we. I could stomach all this. I think the challenge is that's not. It doesn't seem like that's what's going on over here, and it's the differential in terms of treatment or approach to this subjective feeling of harm that I think has made some people feel like Jews are being marginalized in higher education. I always say, if universities want to say, listen, we screwed up. We had this approach and we thought we could really protect people. We were well-meaning. We wanted everyone to feel part of the community, and we adopted these policies and we realized it was a huge mistake. And we get it. We're gonna disavow those policies and move on to full free speech absolutism now, and really make space for everyone to say whatever they want. And we get that kind of. You probably feel not great about that because we only discovered it now. We didn't discover it 5 years ago, and we're sorry about that. We messed up, but we've thought about it deeply now, and we think this is right. And again, we're sorry, and this is how we're going forward. And we promise to be better. I could handle all that, and I would say I would not feel like I could really wrap my head around protests, no matter what.
Is that happening now? Is that happening now? Or
No,
no, it's not
no,
happening.
no chance. I would say I don't. I'd be surprised if the apology I just described is coming anytime soon. And in the absence of that, that kind of, very candid and self-reflective um, assessment of the state of affairs, I think until then, Jews may feel somewhat marginalized. And I think, the legal battles as a result will continue.
A couple of maybe a little bit more personal questions, but what is the most interesting legal case that you have worked on? It could be in this space or some other space.
That's tough. I had the pleasure also of working with the Beth Din of America, which is a rabbinical court, a Beit Din, out of New York. I've worked there in different capacities. Oh gosh, since my second year of law school. It's been a long time. And again, now I work as a lay leader. I'm on the board, but I get asked a lot of legal questions. Um, there's a lot of stuff there. Um, Certainly some litigation I had the pleasure of doing on behalf of a particular Rebbe who was terminated from a high school and won before Beit Din. The Beit Din's award was thrown out, and we were able to get it reinstated. I think about that often. It was the first and really only time, now that I think about it, I ever did oral argument before a court. Like that was um, kind of upholding the standard in terms of how rabbinical court judgments are assessed and enforced in the United States was a big deal. But I think the one that's most personal is the one I mentioned before. The one we have going on now that I have the pleasure of working with the Becket Fund for Religious Liberty and the Orthodox Unions Teach Coalition, the special needs litigation going on in California right now. And it's personal in large part. I didn't know anything about special needs law or the structure of funding, like not a lick. And it really was just the result of a phone call from a friend who I sit on the board of my kids' elementary school with, who had some questions. And next thing you know, you start to uncover some pretty serious systemic problems for the kinds of support special needs families receive in California, especially if they'd like to pursue some form of religious education. And I still remember, there was a time where we all got in a room with a number of special needs families just to listen and hear about kind of the struggles that they face. And I mean, it's tough. You listen to that, and it feels like a certain form of litigation doesn't always feel righteous. I don't want to burst anyone's bubble, but this one sure does. And I think it's been much more personal for me as a result. When you meet people who I think the law is done wrong, and it's done wrong in a way that they've been excluded because of their religious commitments. And I think it's been, as a result, I'd say the most significant litigation I've ever been in.
And finally, you've touched upon this, Professor Helfand. Are you optimistic, pessimistic, or something in between regarding these issues and the future of American Jewry in the United States of America?
Those are weird categories for me. I don't think of I think most people know me. Yeah, I don't know, maybe something in between. I mean, we've built up a lot. There's no question about it. And our ability to marshal political or legal resources to protect our rights are significant. And we have a lot of partners and a lot of friends who really care about this stuff. And I live day in, day out in an institution that deeply cares about my religious life and my professional life, my personal life, my family. So, it's hard to be, when you live under those circumstances, hard to be a pessimist. But the next couple of years are going to be a challenge. And the question is, are we up for the challenge? It's going to require things that are probably uncomfortable. I'd say until like 2019, I wouldn't have described myself as a fighter or somebody who pushes. I think COVID disabused me of that. I oddly had the pleasure of suing the governor here in California during COVID to, again, treat religious schools like other institutions that were allowed to be open. Again, distance and mask and a variety of other things, but just I think we may have been one of the only jurisdictions in the United States where private schools were in principle closed for a year, and the damage that did damage that did to children here was significant, and I would describe as inexcusable. And I think, what I've learned, I think what many of us have learned is, it's nice to be able to rest on the laurels of the American Jewish community that fought and pushed and pressed and built a built infrastructure that made things comfortable. But sometimes infrastructure crumbles a little bit and it needs to be rebuilt. And it feels like that's the stage we're in right now. And we'll find out. We'll find out. Ask me again in 4 years.
Okay, booked. We'll book it. Again,
Good.
Helfand, thank you so much. And you should continue to go from strength to strength, from chayil to chayil, in all of your efforts on behalf of the Jewish community. Thank you very much.
Really appreciate it. Thanks for the conversation today.
Thank you.